introduction about myself. I recognize a lot of faces, so the introduction will be short, but I am a construction senior associate at Bexley Beaumont. I work with my dad, who's a partner at the firm. Both he and I are contentious and non-contentious construction lawyers. So we deal with both dispute work and also transactional work as well.
Oh, you have to go the other side now.
Oh, do you mind just muting yourself, whoever's just joined? Thanks. And we are both panel adjudicators as well. So we are both on the RICS panel and a couple of other panels as well. So we also therefore get appointments in adjudications where we will be accepting submissions from both parties and then making ultimately a decision on who we agree with. So today, what are we going to talk about? We are going to talk about the difference between a smash and grab adjudication and a true value adjudication. We're going to talk about when an employer can commence a true value adjudication in circumstances where it's been found in a smash and grab adjudication that it has failed to pay the contractor a notified sum and the notified sum remains unpaid. The required form, substance and content of payment applications, payment notices and pay less notices. And finally, deadlines, timing requirements for issuing payment applications, payment notices and pay less notices. Before I delve into this topic, just one thing to note, both as an adjudicator and as a party representative, this is probably the most common area that we are dealing with, both smash and grab and true value. I would say we also come across defects, delay claims and the like, but it all comes down to payment at the end of the day. Contractors, employers, every dispute has at its core payment. So I would say that this topic, if you're going to listen to any of the topics that I deal with in webinars, I would say that this is probably the most important and also the one that probably gets slipped up on where they don't know the law or they make a small error. And despite a small error, it can have very serious, significant consequences, as we'll look into today. So hopefully this is something that's really useful to you. So the first thing is, well, what is the difference between a smash and grab adjudication and a true value adjudication? I'm sure most of you are aware of this, but we'll briefly go into it. So a smash and grab adjudication is an adjudication to recover unpaid sums due under a payment application when the paying party has failed to issue a valid payment notice or pay less notice within the statutory or contractual deadline. In effect, you are recovering the monies on a technicality by reference to the payment mechanism, be it the contractual mechanism or the statutory mechanism, where the sum is awarded by default without carrying out a valuation of the application. What that effectively means in practice is that if you have a payment application of which you've applied for the payment of £100,000 and no payment notice and no pay less notice is issued in response to that, then as a matter of law, you are entitled to that £100,000 on a technicality. You don't have to work out the true value. You don't have to go into the merits of the claim. You are entitled to that payment in default. That doesn't mean you're entitled to it permanently and it cannot be opened up. But in that interim payment, in that interim cycle, you are entitled to that monies because it's the notified sum. They failed to issue any payment or pay less notice in response to that. You then have a true value adjudication, which is where you have an adjudication to recover those unpaid sums, but it's based on the valuation of the application in order to determine its true value. So this is where you would be assessing the merits of the claim and deciding on a true value basis of the amounts applied for in that application, what sums you are and are not entitled to. Now, when you are commencing an adjudication, it is not the case that you have to either commence a smash and grab adjudication or a true value adjudication. You can, in one adjudication, bring both. And this case that determined it is a recent case called Bellway Homes versus Sergio Construction. It was actually something that we as a practice were doing well before this case, but it's good that there is now case law confirms this. And what it confirms is that you can bring an adjudication where you plead that you're entitled to the monies on a smash and grab basis as your primary position. And then as an alternative basis, you can say, well, even if which is denied, I maintain that I'm entitled to these monies on a smash and grab basis. You don't agree with me. I, in any event, believe I'm entitled to the monies on a true value basis, so I'm pleading it as an alternative case. And what the case said was that that is not separate disputes. That is one dispute that can be referred to adjudication. And the reason this is important is that unless the contract provides otherwise or the parties agree, you can only refer one dispute to adjudication. But you can frame that dispute widely so that you can plead smash and grab in the first instance and true value in the alternative. And how that would look is you would say the dispute I'm referring to adjudication, which has crystallized, is a dispute as to the sum due. I am pleading that I am entitled to the sum due on a smash and grab basis in the first instance. If and only if the adjudicator is not with me that I'm entitled to those monies on a smash and grab basis, then I'm entitled to them on a true value basis. So that's just the basics of what is the difference between a smash and grab and true value adjudication, and the fact that how that works in practice when you go to adjudication. But just to be clear, you don't have to do smash and grab and true value in one. You can just do smash and grab, and you can just do true value. So the next question is, well, when can an employer commence a true value adjudication in circumstances where it's been found in a smash and grab adjudication that it has failed to pay the contractor a notified sum and the notified sum remains unpaid? So the first case that we're going to talk about is S&T UK Limited versus Grove Developments Limited. And the principle established in this case, I'm going to refer to as the Grove Rule. So I'm going to refer to the Grove Rule quite a lot in this webinar. So this is the rule established in this case. And what it states is that a party wishing to commence an adjudication seeking a true value of a payment application or payment notice must first comply with its immediate obligation to pay and any notified sum due. Otherwise, the adjudicator lacks jurisdiction. So how that would work in practice is, let's say I'm appointed as an adjudicator, and it's an adjudication in respect of a true value. And the responding party raises a jurisdictional challenge and says to me, Mr. Adjudicator, well, we don't believe you have jurisdiction. The referring party has failed to pay a notified sum. There's been a notified sum. The final date for payment has elapsed. They've failed to pay that. We believe, pursuant to this case, the Grove Rule, that you lack jurisdiction because the referring party is not entitled to refer this adjudication until it's paid the notified sum. So that's what the rule says, and effectively that's because of statute, which basically said this that you have to make payment first, then argue about it later. So that is the really important rule, and what we're going to talk about in the next slide is how that rule actually applies in practice. But before we do that, in terms of this Grove Rule, a really important case is AM Construction versus the Darrell Aman Trust. And what this says is that the Grove Rule is applicable whether or not the party has first obtained an adjudication decision as to the notified sum in its favour. So what that means is, going back to the example we just referred to, if I'm the adjudicator and I've been appointed in respect of a true value, and the responding party has raised a jurisdictional challenge stating, well, they failed to pay a notified sum. If the referring party says, well, there's been no smash and grab adjudication, there's been no determination that we failed to pay a notified sum, that's not the relevant question. It's not whether or not there's been a smash and grab adjudication and notified sum been determined as due, which is failed to be paid. It's just simply whether or not there's a notified sum that has been failed to be paid. So there could be before me, as part of a jurisdictional challenge, and which has happened recently in an adjudication where I was appointed an adjudicator, that parties were putting submissions before me as to whether or not there'd been a failure to pay a notified sum. And that was something I had to consider in order to establish whether I had jurisdiction. It's not the case simply, and the referring party tried to raise this, well, there's been no smash and grab adjudication that we've lost on. There's been therefore no established matter of facts that we failed to pay a notified sum. That is not a defence. It's simply whether or not that referring party has failed to pay a notified sum, and therefore I would need to consider that, make a decision as to whether or not I consider that the referring party has failed to pay a notified sum, And if I considered that the referring party has failed to pay a notified sum, then pursuant to that Grove rule, I would have to decide that I don't have jurisdiction and I'd have to resign because the referring party has commenced a true value adjudication, but they've failed to pay a notified sum. Now, we're now going to talk about some other cases because these provide authority on the scope and extent of the Grove rule. And the case we're going to talk about is Lidl Great Britain Limited versus Closed Circuit Cooling Limited. Now, what this case, it actually provides quite a number of points, so we'll go with each of them in turn. The first point is that it says that the Grove rule, that rule we just mentioned, established by the Grove case, is not a blanket prohibition on all true value adjudications. The court in this case rejected the argument that once a notified sum remains unpaid, the paying party is barred from commencing any adjudication whatsoever. So it's not the case that if I decide that there's been a failure to pay a notified sum, that means that you cannot commence any adjudication whatsoever until that payment has been made. What the court decided is that the key question is whether the true value adjudication concerns matters that could have been raised in a payment notice or pay less notice in the payment cycle that relates to the notified sum. They called it the dividing line and said it's effectively the date of the pay less notice. So how that works in practice is, let's say that there's been an application for payment number 18, and it is in common agreement that there's been a failure to pay the notified sum in respect of that payment number application number 18. You then take the pay less notice date that had to be issued in respect of that application for payment number 18, and you consider whether or not the issues in dispute as at that time is what is being raised in the adjudication. So let's say, by way of example, you've got defects that were known as at the date of payment application number 18. You couldn't then refer a dispute to adjudication as to the true value of those defects because they should have been raised in a pay less notice in respect of that payment cycle where the notified sum lies. If, however, there were defects that arose only later, so after the final date that you could have issued the pay less notice, then the true value of those defects can still be raised in a true value adjudication, notwithstanding the fact that there's been a failure to pay a notified sum. So it doesn't bar the party from commencing a true value adjudication completely. It depends on the pay less notice date and whether the issue could have been raised in that pay less notice or not. This case also provided another key point, and it was because parties were trying to avoid and circumvent the Grove rule. And what it says is that the true value has to be interpreted broadly. It is not confined to adjudication simply concerning payment or valuation. Also matters such as defects, deductions, liquidated damages, delay claims, extension of time issues, and declaratory relief in respect of these issues, if those matters could have been relied upon in a valid pay less notice in the relevant payment cycle. So how that looks in practice is, and this is actually funnily enough something that I was dealing with as an adjudicator recently, is the parties did not dispute the fact that the referring party had failed to pay a notified sum. And the adjudication that was referred to me wasn't what is the true value of the defects. It wasn't I'm seeking any payment. It was simply declaratory relief as to whether or not the defective works were defective. And it was put before me as a jurisdictional challenge by the responding party that I lacked jurisdiction pursuant to the Grove rule, and that even though technically this adjudication wasn't a true value adjudication, because you weren't seeking payment and you weren't seeking true value, simply a declaratory relief as to defects, it still falls within the Grove rule pursuant to this Lidl case because you cannot circumvent the Grove rule, and it was still deemed as a true value. The reason being was that the defects could have been raised in that pay less notice in respect of that payment cycle where the notified sum it relates to. They didn't raise it in the pay less notice, but they could have done. And in effect, what you're seeking to do is circumvent the rule because in effect, it is a true value. Whilst you're not seeking payment or evaluation, if I was to decide that the works are not defective, then it goes to value because there was a deduction made for defective works. If I decide that the works aren't defective, then in effect, the deduction is not valid. So it does go to true value. So this case is very important because it gives the Grove rule a lot more importance and says that you can't seek to try and circumvent it by going around it and saying, well, I'm not seeking true value on payment. I'm just seeking declaratory relief in respect of defects, by way of example. And importantly, this doesn't just apply to defects, it also applies to liquidated damages, extension of time issues, etc. So let's say in a pay less notice, you could have deducted liquidated damages, but you didn't. You can't then bring an adjudication in respect of your entitlement to liquidated damages because, again, of this Grove rule, because it would go to true value. Same with extension of time issues. If you bring an extension of time claim, that goes then to liquidated damages, and that then goes to true value and payment. So the Grove rule has very wide ramifications. It doesn't just apply to a proper true value where you're seeking payment or valuation. It goes much wider than that. The final question I've just put on this slide is, well, what about a true value adjudication that encompasses some issues that could have been relied upon in a valid pay less notice in the relevant payment cycle, and some issues that could not have been? So, as I mentioned earlier, an adjudication can be framed quite large. So you could have a dispute that encompasses a number of sub-issues, such as extension of time, defects, etc., etc. And it may be that there's a true value adjudication that encompasses some issues that could have been raised in that valid pay less notice in the relevant payment cycle, and some issues that could not have been. Now, the question is, well, what happens if I'm an adjudicator? Do I resign? Well, what do I do pursuant to the Grove rule? And in my view, you wouldn't resign, but it would go to my jurisdiction as to, and it's called, there's two types of jurisdiction, internal jurisdiction and threshold jurisdiction, but it would go to my internal jurisdiction. What it means is that I may have jurisdiction to decide elements of the true value, but other elements I would not. So if it could have been raised in that valid pay less notice, then I would say, no, I can't have jurisdiction to deal with that issue. But if it was something that could have only been raised after the valid pay less notice, because, for example, defects only arose later, then in respect of that issue, I would have jurisdiction. And what I would do in my decision is separate out the issues so that I can clearly identify which elements I do have jurisdiction and which elements I don't have jurisdiction. So that's the Liddell case. So having now spoken about smash and grab, true value, the Grove rule, we're now getting into the crux of, well, now we understand the importance of a smash and grab adjudication. We now know the difference between that and a true value. How can you be successful in a smash and grab adjudication? And vice versa, how can you defend a smash and grab adjudication and take advantage of this? So to be successful in a smash and grab adjudication, your application for payment has to be valid, and there has to be no valid payment notice or pay less notice issued. If a valid payment notice or pay less notice is issued, then the notified sum is effectively the sum in that payment notice or pay less notice, and it is that sum that has to be paid by the final date for payment. It therefore follows that the question of, well, what is required for these documents to be valid is crucially important. So we're now going to go through the requirements of ensuring that your payment application, payment notice, and pay less notice is compliant. The first thing is that you need to make sure that all the statutory and contractual requirements are met. If they are not met, then it is very likely that your application for payment notice, or pay less notice will not be valid. And it's all a question of fact and degree. So before we go on to the statutory requirements, let's talk about the contractual requirements. I obviously recognize a lot of faces on this call, and I'm sure everyone on this call will tell you that the first thing I always ask when I'm acting for a client is, please, can I have a copy of the contract? The contract is always the important starting point, and you need to be aware of what is stated in the requirement as to payment applications, payment notices, and pay less notices, because you need to comply with the contract. If you don't comply with the contract, then there is an argument to say that your document is not valid because it doesn't comply with the contract. So to give you an example, I have seen it in contracts where there is a bespoke schedule of amendments and it sets out a specific method of service for either the application for payment, payment notice, or pay less notice. By way of example, it has to be sent by recorded sign for delivery. If you fail to do that, then there is an argument that your notice is invalid. So I can't stress enough that you need to make sure you're aware of what is the requirement stated in the contract and that you comply with those. If you don't, then there is an argument to say that the application is not valid. There is a question, and normally gets raised, of, well, we never, even though it was in the contract, we proceeded not to do that and the other side never raised it. Now that goes to a question of whether of arguments of estoppel and waiver and things like that, and we have run that in the past. But whilst that is something that may or may not be successful as a defence, what I would always say as a sort of go-to is check what the contract provides and make sure you comply with that contract. And that doesn't just apply for payment applications, payment notices, and pay less notices, but also if you're issuing a termination notice or anything like that. Just always make sure you're aware of the terms of the contract, any specific amendments, go through that, do a checklist, tick it all off before you issue it. So that's obviously what the contract may provide, and it may provide bespoke requirements that you need to comply with. But as a minimum, what your contract will guarantee provide, and even if it doesn't provide, then the statute will kick in and will say that it has to happen, is an application for payment, a payment notice, and a pay less notice must set out the sum due and the basis on which the sum due has been calculated. If your application for payment notice, or pay less notice doesn't do those two things, then I guarantee you it will not be valid. It has to do those two things. So a payment notice has to state the sum considered due at the relevant due date and be free from ambiguity. The basis for the calculation must be provided, and it must detail how the sum was determined. The test is it must include sufficient information to allow the reasonable recipient to understand the calculation, such as an arithmetical calculation and grounds for any deductions. And importantly, it is the reasonable recipient. So it's an objective test. It is not, well, it's not subjective and saying, well, the employer knew it. He knew what it would mean. He's got knowledge of the contract. No, it's the reasonable recipient, and it's therefore an objective test. Would a reasonable recipient, having knowledge, understand from the arithmetical breakdown the basis of the calculation? So the question is, well, how does this look like in practice? Now, I do advise a lot of clients on sort of the structure and format of an application for payment, payment notice, and pay less notice. And what I say is this: you want to include it. I think it's always easier using an Excel spreadsheet. And what you should do is include a summary tab, being that first tab. And in that summary tab, you should be including all of the items of claim. So preliminaries, like materials, labor, whatever it is that's in your contract, what's in the contract sum analysis is the breakdown. You should be setting out for each individual item what your sum is. And then you add them all together. And then at the bottom of that summary tab, you would say less retention, less previously paid, amount due, plus VAT, and then the final sum at the end, amount due underlined. That final sum at the end of the summary tab is the amount due. So you've ticked the box. And then the breakdown is by reference to the summary tab, and then also the other tabs included in the Excel spreadsheet. And what I would say is you should include a Excel spreadsheet tab for each item in the summary claim. So the summary claim has got the main item, and then the other tabs will have all of the individual items and an amount for each. So you could clearly go to each tab and realize how each sum in the summary tab has been calculated. And the important point is, it is that amount at the end of the summary tab document that is your notified sum. So if that's a payment application and then no payment notice or no pay less notice is issued, it is that sum at the bottom of the summary tab that is the notified sum. So if you're commencing a smash and grab adjudication only, no true value, if you'd like to be successful, you'd get the sum stated in your application. And if you're unsuccessful, you're going to get a payment of nil awarded to you. Now, you can't say, oh, well, I didn't include VAT. I forgot to include the VAT, but I'm still claiming the VAT in a smash and grab adjudication. If I was an adjudicator, I would state, well, you haven't applied for the VAT, and the notified sum is the sum stated in the application. So make sure that if you're seeking recovery of VAT, make sure it's included in the summary tab. Equally, if you've forgotten to deduct previously paid and your application is in a gross sum, that is the notified sum. So if I consider that your document is valid as an application for payment, but that's the sum, that would be the only sum I could award to you if it's a smash and grab. I can't seek to try and correct it and say, well, you would have included previously paid. The notified sum is the sum set out in that document. So you need to just be fully aware of that. So that's sort of how it looks like in practice. Now, I see a lot of cases where people issue payment notices or pay less notices and say, well, I believe that the notified sum is zero. No further sum is due to you, Mr. Contractor. So I've just issued you a document which says zero. That is not going to be valid. Even when you assess it to be zero, you have to explain the basis. You have to arrive at a calculation. So for each item, you need to say 0, 0, 0, final sum, 0. And then for each individual item, what I would suggest is you include a little section where for each one you explain how you've arrived at 0. For example, these works haven't been undertaken. 0% done. And that's what you should do for every single one. So even when the sum is 0, you must do that. For a payment notice to be valid, it has to be in substance, form, and intent a payment notice. Now, I've put that in inverted commas because that's from a case law. That's what it says. It has to be in substance, form, and intent valid. And as I've already mentioned, it has to be construed objectively, whether the reasonable recipient, taking into account the relevant objective contextual scene, would have understood the payment notice as a payment notice. A practical, common sense interpretation should be applied that is not unnecessarily restrictive and ignores artificial criticisms on technical points. Now, all of these bullet points are taken from case law as sort of guidance when looking at the test for payment notices and the validity of payment notices and payless notices and applications for payment. So the next point is that if on an objective reading, the document, the payment notice by way of example, was intended to be a notice or could set the agenda for an adjudication, it probably is a notice. And what they effectively mean by that is a good rule of thumb, a good test to see if whether or not it gives that breakdown, it sets out the basis of the calculation, is whether it sets an agenda for a true value adjudication. So if we've got a true value adjudication and we can look at that payment notice and go through each item and understand where their assessment is, that suggests that the document is likely going to be a valid document. Importantly, you don't need to label your document as a payment notice. That's very clear from the case law. And you also don't need to refer to the relevant clause in the contract. So even though you have to make sure it's in substance, form, and intent a payment notice, you don't have to display that intent by stating, well, this is a payment notice and it's pursuant to clause whatever of the contract. You don't need to do that. So that's an important point. And that sort of links to the fact that unnecessarily restrictive points will not necessarily invalidate the payment notice. So the first case I'm going to talk about, which sort of takes into account these principles and then applies it into practice, is Place First Construction Limited versus CAR Construction Northeast Limited. And what this established was that a payment notice is not required to expressly state that the sum contained within it is the sum considered due at the due date. So what this means in practice is that if you've got a document and on that summary tab, at the end of the summary tab, it includes a figure which is underlined, which you clearly can see is the sum due. They didn't have to expressly state in it, and this is the sum due at the due date. It was sufficient that it was the final figure in that payment notice. So again, it sort of reiterates that whilst you have to make sure you meet all these requirements and comply with them all, they won't be so strict as to say, well, because you've not labelled it as a payment notice or you've not referred to the clause number, that it will therefore be invalid. The next case I'm going to talk about is Vision Construct Limited versus Dripcraft Drylining Contractors Limited. Now, funnily enough, this was actually an adjudication where my dad was appointed as the adjudicator. So my dad was the adjudicator in this matter. It was before him, and he decided that a late payment notice cannot be considered as a valid payless notice. And what he effectively decided is there was a document before him, and it was accepted that it was issued late as a payment notice. And we will talk about this shortly, but you have to issue a payment notice by a certain date. And it was accepted that it was a late payment notice, but they argued that it was a valid payless notice because it was issued before the final date for the payless notice. And my dad decided in this adjudication that when considering the document, he considered that it was not a valid payless notice because it, albeit late, was intended to be a payment notice. It was not intended to be a payless notice, and that was clear from the document. So he decided, no, that can't be the case. Otherwise, every payment notice issued late could arguably be a valid payless notice. And he considered it and said, well, you referred to it as a payment notice, albeit late. It wasn't intended to be a payless notice. And as we've said above, it's substance, form, and intent. It has to intend to be that document. And that document, albeit late, was not intended to be a payless notice. It went to the courts, and my dad was pleased to note that they agreed with him. So they agreed with him that it was not a valid payless notice because, again, of that case law. It was not intended to be a valid payless notice. It was intended to be a payment notice, not a valid payless notice. And what I would say here, therefore, is that if you are labeling a document as a payment notice, but it is then late, it's arguably not going to then be relied upon as a valid payless notice later. The main difference also between a payless notice and a payment notice is that a payless notice, you are notifying them that you're going to be paying less than either the application for payment or the payment notice. So what you're going to be doing in that payless notice is, by reference to either that application for payment or payment notice, stating the amount less that you're going to be paying in respect of that payment application or application for payment. By contrast, with a payment notice, you're just going to be stating, this is the sum I consider to be due. So that's a really important case to know for you as well. And that's a very recent case as well that's applied those facts. The next case we're going to talk about is Downs Road Development Limited, LLP versus Laxmambay Construction UK Limited. I'm going to go into this case in a little bit of detail because there's been quite a lot of reliance upon it recently, and I think they are arguably trying to rely upon it in a way that the courts did not intend to. So just a brief summary about this case. Downs was the employer, engaged the contractor to undertake construction works in connection with the development of land at Downs Road, London. Now, on the 26th of February 2021, the contractor sent interim application 34, stating the sum due is just over nearly 1.9 million. On the 3rd of March, the employer sent payment notice 34, stating that the net amount for payment was 97p. Obviously, that was not to the contractor's pleasure. And the covering email stated, we confirm that a further payment notice will be issued to you in due course. So, and they had done this a lot in practice. The employer had adopted a practice of what they would do is send payment notices valued at either £1 or 97 pence to gain time in order to make an assessment of the sum it actually believed to be due. What it then subsequently did is on the 9th of March, it sent payment notice 34A and a valuation assessment, which provided for a net payment amount of £657,218.50. And that sum was paid by the employer on the 26th of March. And the first issue before the judge was the validity of that payment notice 34, that one that certified payment in the sum of 97 pence. And the judge referred to the covering email as evidence that the sum in payment notice 34 could not be interpreted as being the sum the employer genuinely considered due at the payment due date. So before considering that the payment notice was invalid, the judge highlighted that the payment notice also failed to set out the basis of the calculation and did not show how the employer had arrived at the figure of the gross valuation. So a number of points here. Number one, it didn't give a breakdown as to how it arrived at the 97 pence. It was effectively just a placeholder. So it was invalid because it failed to give a breakdown. And the second point is, because it was stated in the covering letter that they were going to be issuing a further payment notice, it confirmed that that payment notice number 34 was not setting out the sum generally considered to be due at the due date and therefore was invalid. Now, I've underlined the word genuinely because that's something that's sort of been added by the judge. It was clear by case law and what the contractual and statutory requirements were, is that you had to state the sum due at the due date and the basis of the calculation. It never said that you had to state the sum genuinely considered due. And because of that, a lot of people are now relying upon this case to say that there is an additional requirement for the validity of payment and pay less notices, that being that the sum you seek has to be a genuine amount that you're seeking. And what parties are then doing, and I've seen this in practice a lot, is that they're then trying to turn a smash and grab adjudication into a true value adjudication. So if, by way of example, we've got an application for payment and a notified sum, and there's a smash and grab adjudication saying that the payment notice or pay less notice is invalid, one of the questions that may be raised as a defense is, well, it wasn't valid because it didn't state the sum genuinely considered due by the employer. They knew that they weren't entitled to extension of time, but yet they've done this. And or something to that effect, or they say, you knew we had done 80% of the works. Why are you only valuing at 50? You didn't genuinely believe it's 50. It's therefore invalid. Now, the thing is that's then getting into true value arguments, which is nothing to do with smash and grab. And my view is that people have taken this case and then extended it beyond what the judge intended it to be. This was very fact dependent and to do with a payment notice, which was effectively a placeholder. I do not consider that this has some effect that it goes into arguments of true value and whether or not each individual sum within a payment notice is genuinely considered due, because that goes to true value. So again, I stress more than anything that if you're an employer, make sure you're issuing your payment notice or pay less notice on time. And again, for contractor, making sure that you're complying with the contract, you're issuing your application for payment on time. Final thing I'll say before going on to the next slide, which I believe is to do with timing requirements for these documents, is the issue of the notified sum. Let's say you issue an application for payment and we agree it's valid, and there's no payment notice been issued in response to that, then that application for payment is the notified sum and has to be paid if no pay less notice has been issued. Let's say, however, a payment notice has been issued. That payment notice is the notified sum, and that has to be paid by the final date for payment if no pay less notice has been issued. Now, the question that I'm going to ask you is, well, what happens if the payment notice is in a negative sum? If the payment notice is in a positive sum, then the employer clearly has to pay that to the contractor by the final date for payment. What if, however, that payment notice is a negative figure? Does the contractor have to pay it to the employer unless they issue a pay less notice? And the question is, well, it depends on the contract. And unfortunately, I'll be saying that a lot. It always depends on the contract. If the contract provides that there is an obligation on whoever to pay the sum in the payment notice in the absence of a pay less notice, then yes, the contractor would have to pay that sum, that negative sum, which in effect is a payment to the employer, by the final date for payment. If, however, it's silent, then it's typically no, it doesn't have to pay it. But I have seen before, and it also applies to the NEC. So the JCT standard form doesn't provide for this, but I've seen bespoke amendments to the JCT, which provides that if there is a negative sum in the payment notice, the contractor has to pay it if it doesn't issue a pay less notice in response to that payment notice. So if you are a contractor and you have received a payment notice in a negative sum, you need to check the contract to see whether or not it has been a bespoke amended. Because if it's been as bespoke amended and says that, then you've got to make sure you issue a pay less notice in response, or in effect, the employer could commence a smash and grab adjudication for you, seeking payment of that notified sum in that negative figure. So you really need to consider the contract and again, check to see what the requirements are, because I have seen parties slip up on that. And the Grove rule would equally apply to that. So I've had a case very recently where a contractor was trying to bring a true value, but had failed to pay the notified sum in respect of a payment notice where the payment notice was in a negative sum. So you really need to sort of check the contract, be aware of that. So the last thing we're going to talk about today is deadlines and timing requirements for issuing payment applications, payment notices, and payless notices. We've obviously already talked about in the previous slide some of the requirements needed for a valid application for payment notices, and payless notices. Even if you comply with all of that, you set out the sum due and the basis of the calculation. It sets out an agenda for a true value, and it complies with all of that. It's issued in accordance with the contract. You still may not have an valid application if it's issued out of time. So that's another thing that you really need to be aware of. Contract and statute will provide that the notices have to be served in accordance with these strict timeframes. So looking at a case, you've got Leeds City Council versus Waco UK Limited. The court found in favour of the employer and determined that the application had been made out of time by being too early and was therefore invalid. So again, you need to be looking at your contract and you need to be seeing, well, what are the dates for issuing applications for payment? Does it state that if you issue it outside of a certain time frame, it's invalid? Same for payment notices and payless notices. And even if your contract hasn't been drafted very well, there will still be provisions because the scheme will likely kick in and that will provide for certain dates in any event. As to a payment notice, it's going to need to be served no later than 5 days from the due date. If it's served after that, it's going to be invalid. So it doesn't matter if it sets out the sum due and the basis of the calculation. If it's issued outside of that time frame, it will be invalid and it will not be regarded as a valid payment notice. As to a pay less notice, it typically needs to be served within the specified time frame before the final payment date. So if it's late, then it will be invalid. So the standard JCT contract provides that the final date for the pay less notice is 5 days prior to the final date for payment. However, normally employers have a bespoke amendment in the schedule of amendments where they amend it that they can actually issue the pay less notice no later than 1 day before the final date for payment. So if you issue the pay less notice on the final date for payment, then that pay less notice will be invalid. And then they would have to pay, then obliged to pay the notified sum by the final date for payment. So again, the timing requirements are as equally as important as the other points I have mentioned. You can have everything there meeting the contract, but if it's issued out of time, it will not be valid. So what I would suggest is review your contract, make a note of all the dates for each payment cycle so that you can't get it wrong. Now, what I do see typically is you have a payment schedule, and that payment schedule is appended to the contract and both parties agree it applies, and it sets out the dates for the final date for payment, the due date, the application for payment, the payment notice, and the pay less notice. That makes my life a lot easier when it comes before me because we can clearly agree where all the dates apply, and then you can clearly see, right, did they issue the pay less notice by that date stated in the schedule? The final point I would mention on schedules, which I do see often and are sort of increasing in prevalence, is that there's a table and the table's then finished and there's nothing else. And that's because they never foresaw that there would be delays and things of the like. Now the question is, after that final row in the column in the table, can you then issue further? Is there further interim cycles? And if there's no writing, then it's been clear from case law that you can't then issue further applications for payment until the final one. So what I stress to all of contractors is that if you're agreeing to a payment schedule and you don't want to include endless rows to make the table really long, you need to include some writing at the end of the table that says if the project is delayed or extended and further dates to apply, these are to apply as follows. And you could just say the due date, the final date of payment is X amount of days after the due date. The payment notice is to be no later than 5 days after the due date, etc., etc., and that is to apply on a monthly basis. And by having that wording, you're then for saying that you're entitled to issue further interim payments. But if you don't include that wording, there is a strong argument that the table only applies. And once you've reached that last date, if the project's still ongoing, you can't seek any further payment until that final account is being dealt with. So that's a really important point to know if you are dealing with payment applications. So I hope that's been of use. I've just put down my mobile number and my email. So if you've ever got any questions, then obviously please feel free to contact me. But I'm just going to check now. Is there anyone that's got any particular questions now, and we can sort of answer them if there's a bit of time available?
There was one question quickly, Brandon, about whether the slides would be circulated afterwards. Is that something you're happy
Yes,
to do?
so that hopefully it's being recorded as well. I hope you all don't mind that. I
been.
should have probably said that at the beginning as a disclaimer, especially being a lawyer. But yes, the slides will be available, and I'll also be sort of circulating the recording as well.
Fab, thank you.
Is anyone else? This is the dreaded part where I ask if anyone's got any questions and everyone goes silent. But is there anyone that's got any questions? If not, or wants to email me instead, obviously happy to answer those anyway.
There has been a question in the chat.
Okay, yeah.
With regard to the objective reasonable recipient test, what do you consider to be the relevant objective contextual scene?
So I would say that having regard to what's happened previously is important, because if you're an employer and you've obviously been issued previous applications for payment, that's in your knowledge. So that is some of the contextual scene. Also, if there's anything been agreed between the parties, that's again contextual scene. So it's having really regard to any relevant facts or circumstances which the reasonable person is to be aware of when taking it into account. So that's sort of the generic things to look after. But unfortunately, it is very much fact dependent. I did only gloss over it just because it's not the easiest topic to sort of segue in, but you've got what happens is that you have got the sort of defense of estoppel and waiver. And what you could say is, let's say you've got an application for payment and the contract says it has to be issued on the 10th of the month, but you've been issuing it on the 12th of the month and the employer has never said anything. There's an argument that even though the contract says it's the 12th, but you've issued it on it says on the 10th, but you've issued it on the 12th, that it is still valid. And the argument would be that the employer is stopped from relying or waived the contractual provision pursuant to the conduct of the parties. But it's very fact dependent. And if it's, for example, let's say by way of example, you've only issued the application for payment on the 12th once when it should be the 10th, that wouldn't be enough to establish a form of estoppel. But if, for example, there's been 30 interim cycles and every single one without fail you've issued on the 12th and not on the 10th, but each time they've issued a payment notice, I would consider on those facts that a strong argument to say that the employer is stopped from saying that your payment application is invalid by issuing it on a different date to the contract. So that is a defense sometimes available, but it's very fact dependent. And also you're before an adjudicator, and unfortunately sometimes they don't like those kind of arguments. So what I would always advise is just make sure you're aware of the terms of the contract and you comply with that. Don't seek to try and think, well, it was waived or stopped. My advice is always still try and follow the terms of the contract. Any other questions for me?
Brandon, I've got a question. So I know you briefly touched on it, on the payment notice issued by an employer of 0. So I've had employers before where in their heads they think, well, I've issued your payment notice on time, but obviously now you've confirmed that because there's no substantiation or backup to anything, it's just one page saying zero, it's invalid. What can the contractor then do?
So when you say zero, have they in their sort of document, have they set out zero for each individual item, or have they just said one sum of zero?
That's one page which has some of the particulars of the contract, and the sum due is zero. There's no substantiation or explanation as to how they arrived at zero.
So yeah, then obviously have to see the document, but my advice would be that would likely not be valid, and therefore you can run a smash and grab on your application for payment, provided your application for payment is valid. Because like I said, even if the sum is zero, you have to set out the sum due. If you said zero for each line item, and then in the tab for each line item you stated zero, that is a breakdown. Albeit every single sum is zero, you could put for each individual line item 0, 0, 0, 0, no substantiation, no substantiation. If in those circumstances, then it's likely the payment notice is valid and you couldn't commence a smash and grab. But what my advice would therefore be to you is that if you don't obviously agree with the zero figure, is to then commence that true value adjudication. A dispute will have crystallized once the final date for payment has elapsed, because you've issued an application for payment in X and they've issued a payment notice in Y. There's clearly a dispute as to the figure, and you can commence that true value. Obviously, it then goes down to substantiation, and obviously they've said that there's no substantiation. So yeah, you can commence a true value. But like I said as well, you always have the option, and sometimes I have clients that deal with this, where we plead smash and grab in the first instance and true value in the alternative. You don't necessarily have to do one or the other.
Cheers, Brendan. Very helpful and good seminar. Appreciate that.
No worries. Thanks, Damien. Any other questions that anyone's got? Please don't be shy. No, if there's no other questions, then obviously thank you everyone for listening. Obviously, it's just after the bank holiday, so and it's also very, very hot. So I appreciate everyone sort of listening in. We will be doing these sort of every quarterly. So if there's any specific topics that anyone wants me to sort of talk about, then please drop me an email or a line, and obviously we'll look to do that. But the next one will be in about sort of 3 to 4 months time. But I appreciate everyone for listening, and yeah, these slides will be circulated and also the recording, so you can obviously listen to it again as sort of a reference point later. Okay, thanks everyone for listening.
Thank you, Brandon.
Cheers.
Thank
Thank you.
you.
Cheers, Brendan.
Thanks. Bye-bye.
Cheers.